Today we have a very practical seminar where we talk about some of not only the weaknesses of the different asset protection tools, but how to ameliorate those weaknesses with other tools. So it's kind of a combined, when clients come in and they want to do planning, it's a combined approach where we take a look at all of these different tools and we integrate them in a customized way for the client. So let's go through the agenda, not the addenda. I've been writing so many addendas. I've been, don't know what I'm doing. The agenda for today is it's really an overview of the tools and how they integrate, with a little bit of history showing, for instance, cases where people have failed to integrate tools and why that can lead to the downfall and the breaching of asset protection plans. We'll start with an overview and then we'll get into business entities, jurisdictional issues, some of the details associated with the weaknesses in the LLC and how we can ameliorate those weaknesses and fortify LLC structures, offshore options. We'll talk about exempt assets a little bit. Then we'll talk about trusts, and there'll be a kind of a constant interplay with titling as well. How should these be owned in terms of who should be the owner and why? And then, to the extent we have time, we'll get into some of the tax side and how that's impacted somewhat on which tools we use. The goal on asset protection, and one of the reasons it's not really taught as not yet, it's about to be taught, but it's not currently taught as a kind of a class in law school, or it's not really viewed as a practice that you would study for instance, is because it involves all these different areas of law. The goal is when you're sued that you've utilized all these areas of law such that your assets aren't exposed to the litigation. You don't hide assets. It's not a reaction to a suit. It's really purely planning. So the basics in terms of the tools and background that we implement on an asset protection plan, before we get into how we mix these together and integrate them, are titling. How do we actually hold title? In other words, if we have a single individual, do we title an LLC in the name of the individual? Do we title the LLC in a trust? Do we use a number of LLCs? If we have a married couple, do they title assets together by the entireties? What state are they in? Are they allowed to title assets together? What type of asset is it? For instance, some states allow tenancy by the entireties and some states don't. That's the titling issue. Exemptions involve assets that in and of themselves are not available to creditors. There's no business entity that's required. There's no particular titling that's typically required. There's no trust that's required. It's if you own the asset and it has value, that value is not available to people that sue you. It's an exempt asset. There are many restrictions in the various jurisdictions, so you have to choose the right jurisdiction. Sometimes you don't have a choice. We'll get into some of the details of that. And then trusts basically are a 500-year-old arrangement where assets are put in the legal title of a trustee. Some states say, well, most states say you have to put those assets in the legal title of another trustee. It has to be somebody else. It can't be it can't be really the grantor or for the benefit of the grantor. We'll get into some of the details of that, but now we have jurisdictions where someone can set up a trust for themselves, for their own benefit. But the idea with trust historically is that assets were put in to trust for the benefit of someone else and controlled by someone else. So the control person has legal title, and the beneficial person who benefits by the assets has no legal title, just beneficial interest in the assets. And this division of title protects the assets. So if the trustee who holds legal title is sued, they don't have the benefit of the assets. If the beneficiary is sued and the beneficiary can't reach into the trust, there's nothing the beneficiary can get, so the assets are protected. And then, like I had mentioned, you have the entities, which has typically become, for all essential purposes, the LLC. And choosing the right jurisdiction is the key to that, making sure that if a particular jurisdiction only protects a certain type of LLC or a certain multi-member LLC, et cetera, that all of those requirements are satisfied or blended with another, for instance, exempt asset or titling, so that we don't fall into an exposed situation because we didn't follow either the statute or the cases in that jurisdiction. So we had mentioned this transfer of title, transfer of control. Maybe you have to give up control, maybe you don't. And then how we integrate these different tools to eliminate or substantially eliminate the weaknesses that may be involved in using one or the other. We start with the entities, typically referred to as business entities. The way that business entities offer asset protection are both inside and outside. So inside the entity, you operate a corporation or an LLC, you operate a business, or you operate an investment format, portfolio, or however that business is operated. Inside, if someone is unhappy, like someone is a customer and sues based on the business operation, and you operated it like a business, the owners are not liable. That's an inside liability. Phone bills, energy bills, someone falling in the business even, the owners in general are not liable. The owners would have to do something to kind of disregard that entity or treat it as a piggy bank or use the entity for fraudulent activity to be liable. That's called inside asset protection. Corporations, which until recently were more numerous than even the LLC, offer this inside asset protection. That's why people use corporations. Sometimes people don't know why they use corporations, believe it or not, but that's why they use it, because if they operate the business, things, liabilities, exposures that occur in the business do not impact the owners in general. So what's the problem with the corporation? The problem with the corporation is that if the owner of the corporation gets into trouble, the owner of the corporation basically holds assets. The plaintiff comes in, sues the owner, takes exposed assets, which include corporate stock. So the corporation itself, the equity is not protected. That's why we move to more protective entities. We look for entities with outside asset protection. So we're all set in corporations inside. It's the outside that now we're focused on in terms of protecting that equity. And basically what we moved through in history was we had the partnership, which, let's see here, yeah, that's the next slide, which offered an outside protection in that if someone sued a partner, the law developed such that it was the policy of the law that if one partner was sued, it would not affect the other partner. So if someone sues a partner, whether that be a limited partner or a general partner, the plaintiff cannot take the equity of the partner. They can just lien it. So if there's a distribution that goes out, the lien holder would receive that distribution. That's what they'd be entitled to. That developed over the years into the idea of, let's kind of equate the partnership to the corporation in a sense, in that this L and LL was put in front of the P, the partnership, because the partnership, although it had this outside protection, was really sparsely used, and at this point, pretty much it doesn't make any sense to use a partnership, because the general partner is not entitled to inside asset protection. It started as a handshake issue where you created a partnership without a document, and you were liable for everything that happened inside the partnership. So no one would form a partnership. So there was a move where they put this L or LL in terms of limited, they put an LL. So you had a partnership, so you had a limited liability partnership, or you had limited liability limited partnership in front of your partnership. And that eliminated this exposure to everything that goes on inside a partnership. And then everyone realized, well, why don't we just do an LLC? I don't know why Florida went through this gyration in the late 90s. It had something to do with the fact that Florida was considering the LLC, but they wanted to tax it the way they tax corporations. I'm not sure any of that is highly relevant at this point, in light of the fact that we only have 50 minutes. We won't go through the entire history. So the limited liability company adopted the idea of this outside protection. So if someone sues a member, which is an owner of a limited liability company, the plaintiff can only get a lien on equity. And the limited liability has inside asset protection. So if something happens in terms of the business operation, the owner's not liable. So you have both. You have inside asset protection and outside asset protection in terms of the charging lien. You got to be careful with LLCs. LLCs, you kind of write your own rules in their operating agreement. Also, the different jurisdictions offer different LLCs. They're not all the same at all. And that charging lien, for instance, in some jurisdictions, the plaintiff can come in and foreclose out that charging lien. And what that means, no one's sure. But in other jurisdictions, they can foreclose it and actually take assets, get to equity and take assets of the LLC. So it really depends on the jurisdiction you're dealing with.
Also, I think it's important to note that all of these distinctions are state law issues as relate to property rights, do not regard taxation. And, it's important to know, like an LLC, you have options to be taxed as almost anything, to be disregarded, partnership, or S corporation.
Yeah, and that was another advantage that the LLC brought, was where a corporation can either be, a C or an S corporation. The LLC, you can go into the partnership tax rules and become a partnership or a disregarded entity, which is very helpful. It creates a huge amount of flexibility with respect to just picking LLC over corporation. Some of the other issues we hit here in the slide where it also, there's no annual minutes, it's a lot more relaxed. But because it's more relaxed, you have to get the organizational documents and the operating agreement right, because you're making your own rules. Whereas with a corporation, if you were just very lax about it, the statute's more detailed.
Also, it's very common when a lot of times they form a state law corporation to be an S, and that's not necessary. We see it a lot of times when it's older, that they'll have a state corporation taxed as an S when it should be an LLC because of the protective nature of all the things they'll offer.
Oh, right. We'll have older entities that should convert to LLC status just to offer those protections, and we do that all the time. One thing it's hilarious in kind of a sad way is that we'll actually have a structure. Someone did a structure which is somewhat protective, and then they'll actually put a corporation on top. So they'll own it through a corporation. They've obliterated all the protections because now someone could sue them and just take the whole thing because a corporation owns the whole structure. You've got to be careful with the way you calculate all of the different tools. So here's a wrap-up slide where we talk about, let's go with LLC. Let's get the outside protection. Let's get the inside protection. let's pick the right jurisdiction, and then let's talk about where to form. In other words, do we form it in the states? Do we form a single member LLC? Do we form a multi-member LLC? Does ours, would, if we're sued in our state, would that state protect a Delaware LLC, an offshore LLC? They're supposed to, and according to some of the black letter law, but sometimes they just don't. So you have to keep that in mind. And then why don't they? And maybe we can address that, and maybe we can do some titling or some exempt work to eliminate the exposure. When we look at which LLCs are good and which LLCs aren't good, one of the issues is, did the state use the revised Uniform Limited Liability Company Act or not? Some of these uniform acts are, they're very intelligently done for the most part. What you have a commission that sets out these uniform acts, because that way you don't need people like us to figure out what the differences are between the states, because there's some uniformity. It's easier to deal with. However, it's almost never uniform in terms of what the states actually adopt, because you've got, you banking lobbyists and plaintiffs lobbyists, and so you end up with kind of a hodgepodge. But in general, you want to kind of stay away from a lot of the uniformity with the LLC Act, because there is some exposure, some creditor friendly language in terms of foreclosing out the charging order, other aspects of it that you want to avoid. If you're in a state, for instance, that has one of these exposed LLC statutes, use another state. Use another, to the extent that the courts there have promoted that, or you think may promote that, you should just use another state. A lot of times what asset protection does in terms of planning has nothing to do with okay, we know this is going to happen. It has to do with, well, maybe we can avoid it. In other words, if your state's really bad, if you're sued, you're going to lose your LLC interest. You're going to lose your LLC interest. You might as well use another state, even if it's possible that your state court or whatever courts in your local jurisdiction isn't going to uphold it. If it's still better than going with your state LLC if we know that's not going to give you any protection. Did that make sense?
That makes sense.
Okay. It comes down to this internal affairs doctrine. It's helpful when the state itself, like Florida has a statute on this internal affairs doctrine, which in general says that it says our state will follow and respect the internal affairs of the corporate statute of another state. And that's pretty much all it says. We wish it said internal affairs includes any kind of protective or charging order language or lien language. Doesn't say that. My impression was when it was originally contemplated that it meant that basically you could form an LLC in any state, and our state would respect the internal workings of that statute until we were in the mood to do something else. So the legislature, I think, kind of got it right, but it's not the clearest statute, to say the least. That some of the issues that are raised by it are on the slide of statute of limitations, the treatment of inside transfer, and this charging order lien issue. So should jurisdictions be combined in a plan? Yes, jurisdictions should be combined in a plan, of course, depending on which jurisdiction governs the residence of the client is a major factor. So for instance, if we have a situation where we have a single person in Florida and we just can't get around the fact that this single person would like to own an LLC. Well, Florida is very, very weak in terms of its protection of the single owner LLC. So we want to look at Delaware, which says that they explicitly protect the single owner LLC, or Nevada, or Alaska. We'll get into some of the specifics of that, but the answer is yes. Let's use the best LLC. Let's use the best trust statute we can. When we go into the choice of law, we rely on this internal affairs doctrine, and what we find in general is that when we plan, when nothing of adverse is going on, and we can sit back and contemplate what the best structure would be for our purposes, it works really well. It works really, really well.
But that happens.
It happens.
It happens.
It happens. I mean, it happens with the planning client, and we'll combine it with what happens. I mean, it does happen. What Brian is saying in terms of some of the exotic issues. I know this is going to shock everybody, but they'll see us after they've had a problem. But in terms of the day-to-day stuff, we do that all the time. I mean, we do it all the time.
We recommend it. They plan, they structure.
Yeah, and we'll catch it. We'll catch it a lot of times early. We'll have some estate work, like I had mentioned, and we'll add in all the asset work. That's day to day. We get a lot of the law in terms of what the courts do to interpret the statute from people who are essentially crazy. And they're basically running away from everyone to try to stuff assets that are exposed into structures that generally work. But the law doesn't accommodate that for a number of reasons. But principally, you can't move assets that are exposed into a protective structure or purchase protective, exempt assets just willy-nilly because you're in trouble or you want to hide them. The law in every jurisdiction allows those transactions to be reversed such that the plaintiff can come in and grab the asset. We have a couple examples here where we had this Sabrina Barber who was sued by Wells Fargo. It's a very colorful case. She just went absolutely berserk and starts funding offshore LLCs and Delaware bank accounts. She made a strategic error, from what I could tell in the case, where she actually sold her homestead in Florida, which is protected, which I think would have been protected. Possibly Wells Fargo was the mortgage holder. Maybe that's why she sold it off, but the equity was protected. Anyway, she reacted to being sued on $64 million in real estate foreclosure issues. And one of the things that she did was she funded an offshore Nevis LLC, which is a very protective entity, but it's an example of how far the court will go on these reactionary transfers. And reactionary transfers are not what we're talking about in terms of blending strategies. The court actually came up with a theory where the Nevis LLC, they said, no, we're going to treat it like a Florida LLC. And I'm not sure what that means or how that works. I debate this with my partner, Eric Bowman. And I say it's a Nevis nickel. It's not a Florida nickel. But anyway, they called it a Nevis. They called it a Florida nickel. And Florida, it was a single member LLC. Nevis protects a single member LLC. We had written that statute a long time ago. And they said it's Florida. Florida doesn't protect the single member LLC. We're going to just take everything in the LLC. And she had the assets in Florida, which, that's just too tempting for a court anyway. On that case, by the way, I thought it was a fraudulent transfer case anyway. I mean, you can still apply fraudulent transfer law if she's here and she moved everything to try to, escape from Wells Fargo. It's kind of a loser case, but it just tells you how far the court will go to get to assets. In this JP Morgan case, it's an interesting survey of jurisdictions. In terms of blending approaches. In this case, there was a suit in, I want to say, New Mexico, and it resulted in a judgment. but the defendant came back, had to get to assets in Colorado through a Colorado LLC. So now you're in Colorado, you're in front of a Colorado court. It's not a fraudulent transfer case, and the Colorado court said, no. It's a Colorado LLC. The Colorado LLC does not let you reach in to the entity, and we're going to uphold it. It just goes to show you where you litigate, and the circumstances are very, very significant. So when you're blending strategies, one of the strategies, even as an afterthought, is to get into a jurisdiction where you can actually sue in that jurisdiction and they can protect their own laws. Because Florida doesn't care about what Nevis is doing. Florida probably will uphold the Florida protection. That's our experience. In this case, the court went even further. In Arroyo, the court said, no, you had litigation in Maine. It's a Delaware LLC. We're in Alabama. They threw their hands up. We don't know. We don't want to know. If you want to know, you've got to go to Delaware. We're not going to interpret the Delaware LLC. Go there. So completely protected the LLC in that case. And I think a very protective case in general, actually. I think they might have even gone a little too far. What I want to get to is, this is the Arroyo. What's going to happen? Arroyo v. Barber. The bottom line on a lot of that stuff is, if you do your protections on a sunny day and you're methodical about it and you pick the right jurisdictions, it'll probably be upheld. And the Arroyo type judgment is easy for a judge in that case, because you're not running away from anybody. Now we get into the single member LLC, which we typically want to avoid in general now, because there's this wave of cases that doesn't like the single member LLC. In other words, what that means is someone sues the owner, that the charging order limitation won't apply. They let them take the LLC. Florida's made that clear at this point. We had an initial case, this Albright case, which was a bankruptcy case where they said, we're going to go ahead and take this movie star's, all of her single member LLCs, because the intent goes back to that partnership issue. You have to have a partner you're trying to protect. If you don't have a partner you're trying to protect, this idea of being limited in terms of protecting your equity to a lien, we're not protecting another partner, so we're not going to apply it. Even though the Colorado statute did not say that. The bankruptcy courts, bankruptcy is not really an option if you have assets to protect. The idea of bankruptcy is that you get to discharge your debt. Once you discharge your debt and that trustee's in your shoes, he's going to, there's no expectation that assets will be protected. And this is just how far the court will go. They're going to take the LLC interest. And this is a jurisdictional slide about, which jurisdiction in terms of the LLC, the single member LLC you should choose. You should choose, if you have to go LLC, one of the jurisdictions, including Delaware and Nevada, which says we protect the single member. It says it in the statute, the single member LLC, we protect it. Well, there's a note here, and Wyoming does too, but Wyoming had some problems in terms of allowing for the evisceration of outside protection in a conglomerate, which everyone's pretty much fled Wyoming at this point. Now you get into, okay, how do we blend protections in light of the fact that we don't want a single member LLC? So a lot of clients will come in and say, well, I want to give 1% to my kid, or I want to give 1% to my wife to avoid single member protection. Well, we know what California is going to do. So California will, blaze in kind of a scorched earth fashion sometimes to the trail. And in this case, I thought it was enlightening though. I mean, they did blaze the trail. I thought there were some abuses in this Curci case, which they did address. This Curci case involved a very wealthy defendant who had a family structure in place with hundreds of millions of dollars in it, was sued on a fairly small and relatively speaking loan, and just said, you know what, I'm not paying you. That was the impression. I'm not going to pay you. I'm all protected. And there was a case in California that said you can't take equity like that. You can't take equity. It was a little broad, the case, because it was a corporate case, and corporations you can just take anyway. So I think really the court was right, that the case really meant that that remedy does not apply in terms of the breach of the charging lien to corporations. But with LLCs, now they're looking, okay, should we allow someone to break into an LLC beyond just getting a lien? So this Curci did get the lien. And prior to the lien, Baldwin had distributed $178 million in like dividends, distribution. And so the courts, is exasperated by the whole thing, and said, you know what, we're going to remand this back down to the trial court and allow this plaintiff to go ahead and take to allow the case. It's basically saying we're going to allow the trial court to decide if the plaintiff can take equity in this family LLC. And the way that the LLC was set up, it was 99, I think it was husband, 1% wife. And there was some complexity with trusts, which was just a terrible idea. Curci, Baldwin, the defendant, does seem a little bit cavalier, which is a problem. But, there was no mention of the fact that this was a Delaware LLC. That even if you boil down to the fact that it was a single member, because there was only 1% in wife's hands, Delaware protects a single member LLC. How could you have eliminated a lot of these issues? Well, I think the case in terms of blending protections was against Baldwin, the husband. Well, Delaware allows for tenancy by the entirety titling, which means that you have to have a case, if you properly title, against both husband and wife to reach anything titled as such. So if we create an LLC in a jurisdiction that we think may have some weakness, and we have husband and wife that are happy to take title together, well, we use the tenancy by the entirety to the extent we can. Now, does it work every time? It would work in jurisdictions that allow tenancy by the entirety. I believe California, it's limited. It's limited what you can title tenancy by the entirety. So in California, if you have a Delaware LLC, can you title it tenancy by the entirety? No one's touched that. I think you probably can, because Delaware allows tenancy by the entirety. It is a Delaware LLC. Just putting it out there. I think you probably can. In any case, you should try. Because California is principally community property, which usually conflicts with tenancy by the entirety. But you would do it in any case to create the argument. So there's one where if Baldwin is sued alone, can't get in. Now, the argument then becomes, is it a single member LLC? Husband and wife? No one's really made that determination. Is a husband and wife together a single member LLC? Can we breach it? Well, in that case, if we have children, and even if we don't want the children to have any control or say or shareholder rights, we would create trust for the children, and we wouldn't put too nominal an interest in the trust's hands. We put at least a 2 to 5% interest in. Now we've got a multi-member LLC. It's very hard to argue that a tenancy by the entirety, LLC with additional owners,
entities that are distinct.
Absolutely. And distinct owners is not a multi-member LLCs that which you can only charge at the best you can charge, because you can't charge a tenancy by the entirety interest if it's respected. You blend all of those concepts, the LLC, the TBE, the tenancy by the, and the trust. Very powerful. We've been doing that for a long, long time. This is just the Illinois court said you cannot get into an LLC, which is very favorable for the creditor. You still would blend them. There's no real drawback to blending these strategies. So what the trust for the kids, as we move from LLCs to trusts, you add the members. So you eliminate this single member LLC issue. I think you do. You probably don't want the parents who are in the TBE to be the trustees.
You want a third.
You want a third party or a professional. But I think you're going a long way to limiting the idea of a single member LLC. And the kids in the trust don't control the trust, and they don't even vote the equity, or you can use non-voting equity for the trust. Remember though, as you push away from reality, as you eliminate voting, as you move things more to a passive position to the other members, you open the door to these rulings that say, no, it's not real. This is a single member LLC, I'm going to take it. And we don't know yet. We don't know how that's all going to shake out. We've been waiting a long time. Offshore options is another blending. We've got a number of mergers and acquisitions going on. When do we use an offshore option? When do we combine it with the domestic trusts and LLCs? Well, we may have a business seller that's under a huge indemnity obligation. We may want to move assets offshore to be held in an offshore, usually a trust, or maybe a trust that owns an LLC, outside the jurisdiction of the court that's going to hear the indemnity claim. Very powerful, very powerful, very hard to reach that, especially in a planning scenario where there's no running away, there's no existing creditors. It's very powerful and really requires a huge undertaking by a creditor, a huge expense to try to even attempt to reach into a Nevis LLC, a Nevis Trust, a Cook Islands entity. And then the statute itself is outlined here, where some of these charging order and fraudulent transfer statutes of limitations are very quick. You have to act very, very quickly to even try to get in to these entities. That's a blending that occurs as an aspect of the plan. So if someone gets $100 million in a business sale, maybe 10 million's abroad. Just so if it all goes badly, you have a block protected. This is just some of the corresponding issues when you decide to use an offshore entity. There is quite a bit more IRS reporting, the tax rules change, and if you get into one of these situations where you're not planning and you're reacting, it is going to be viewed under a pretty strong microscope, because the courts are not going to be familiar with offshore entities and these exotic issues, so they'll probably look at it pretty hard. One of the issues we had touched on was, if you do use the offshore entity, you want to hold the assets in that entity abroad, because like in the Barber case, the court was very tempted. Now she completely went off the rails, but in that case, the assets were here, and I think it was very tempting for the court just to grab the assets.
And they did.
Oh yeah,
yeah,
immediately.
The whole reason having an offshore jurisdiction is to put the asset outside the jurisdiction of the court.
That's a major factor. This is the TBE again. If in fact you have a single member LLC, for instance, let's add the spouse if we can. Let's add the spouse, and then let's add additional members, trust for the kids. If you absolutely have to be a single owner, I think it's the next slide. Yeah. Let's at least hold through one of these asset protection trusts. If you don't want to go offshore, 18 jurisdictions now say, okay, if you're a single person, you can drop your LLC, which is exposed. I would say it's exposed at this point. The degree of which is going to depend upon the jurisdiction and the court hearing the case. But I would say it's somewhat exposed. Let's add it to a self-settled asset protection trust in Nevada, South Dakota, which says if I put something in the trust and I use a Nevada trustee, Nevada statute says you cannot reach it. You cannot reach it on a later claim. That is your answer for the self-settled trust in terms of the single member LLC. There's all kinds of trusts. I'd like Brian to say a few words on the tax. So I'm probably going to rush through this a little bit, but these are just some backgrounds on the type of trusts. This is that self-settled issue. You have a number of jurisdictions that allow this. Whether it works or not is somewhat untested. Florida does not have a self-settled trust statute. You cannot create your own protective trust in Florida for yourself. You don't want to go bankrupt. This is the Uber case where he essentially just there were no formalities to his setting up a Alaska trust. All the assets were in Washington. He was in Washington. The co-trustees in Washington. They went bankrupt. Bankruptcy courts are going to do whatever they want to get to the asset. They basically threw it all away and took everything. And Mortensen, that's the mountain man, where he actually did his own trust. He did a pretty good job. It was protected. The statute of limitations had run on fraudulent transfer. He got into a divorce. He decided to go bankrupt. He extended. This is why you have to have competent counsel.
Yeah.
He chose to go. He extended to 10 years. The statute of limitations. She then took everything. It's kind of a crazy.
Yeah, don't file for bankruptcy if you have a plan, basically.
If you have assets.
Yeah.
If you have assets. If
Right.
you're just mired in debt, it's great. And some of the technical portions of those self-settled trust statutes have to be complied with. That's this Bertrand case. Trusco was very interesting because that was a case where the defendant had notified the bank that everything went into a protective structure. And then you have 4 years. The bank has 4 years to reach the, after 4 years, there's no claim. There's no claim on transfer. The distinction is if you don't tell the creditor, the creditor is unaware of the protections that you've done, and an issue comes up, they defaulted on a construction loan, they can claim fraudulent transfer because they didn't know about it for a year after they find out. So that runs. You want to eliminate that running period by telling the creditor. We've done that many times. And this is some of the pieces where we integrate trusts with LLCs. If we have trusts that hold a number of properties, for instance, let's put each property in its own LLC so that if someone falls down on one property, it doesn't wipe out all the properties. This we went through some of the foreign versus domestic, why we do foreign. It creates that offshore layer. Some of the drawbacks to the domestic are the Full Faith and Credit Act and the Constitution requires plaintiffs in every jurisdiction to file their judgment in every other jurisdiction and collect. We have defended the Nevada LLC statute, though. And I'm sorry, the Nevada LLC and the Nevada trust statute. So that self-settled trust where someone had a Florida judgment, we actually defended it in Nevada. So, but we, you know, if it was offshore, you probably wouldn't have even had to do that. So you pick your jurisdiction with these trusts. This is kind of an amalgamation of a number of things where, you know, we want to kind of keep the assets offshore in a foreign trust. We want to issue stock certificates because now we have a court that says, well, it's where the stock certificate is. So if the stock certificate is in a protective jurisdiction, even though they're in Florida, the court says, well, you have to go collect in that foreign jurisdiction, which is a huge burden on the plaintiff. And then we have a new court in Florida that says, well, maybe that's not the case. That area of law is developing. There are some different foreign trust jurisdictions we like. what's the keys to the effectiveness? Honestly, the keys to the effectiveness are start early before there's any problems, and then pick a jurisdiction based on your particular circumstances. And then Brian's going to spend a few minutes on some of the basics in terms of the LLCs, this flexibility, and then the trusts, how we integrate some of these tax issues into the plan.
I think is just to reiterate what Gary spoke to before, the key is you can use a domestic one and it's very effective, but if you're offshore, it's an extra barrier to collection because all the assets are outside the jurisdiction of the court trying to get them. And that's great, but understand that if you go offshore, there are compliance issues and potential income tax consequences, believe it or not, to utilizing a foreign jurisdiction. And if you're a U.S. resident that creates and funds a foreign trust. And just you need to be aware of it. And this is, I mean, there's a lot on this, but I just wanted to give you some broad strokes to be aware of.
It's a factor.
It's a factor.
It's a factor in
It's
choosing which
definitely a
tool
factor.
to use.
But you need to know it's there because, you know, if you do have a foreign trust and it can be a pitfall because you're unaware of what's going on. And this is depending on the nature of the trust. Normally a self-settled trust normally would be, at least from a state and gift side, an incomplete gift because you're benefiting from the person that made the trust is going to benefit from. And so you think, okay, well, I'm going to do this, you know, and it's offshore and I have U.S. beneficiaries, myself and my kids or whomever, and you think it's an incomplete gift and I'm okay. And that might be true on the estate side, state and gift side. But on the income tax side, that's not the case. Because when a U.S. resident puts assets in an offshore trust, it's as if they took those assets and they expatriated with them offshore. And so regardless if it's a completed gift or not, the tax code says it's a deemed sale of those assets on the funding of the trust. That's the basic rule, and that's under 684. The exception to that, which delays it, is if you have a U.S. grantor and you have U.S. beneficiaries, then they postpone that and it's treated as a grantor trust until the earlier of the grantor dying, or there's no longer a U.S. beneficiary of the trust.
Right. So the delay until grantor dying is very significant because the strategy may interfere with your ability to do estate planning and gifting, which deals with the basis in the property at death. Go ahead and explain that, because I think that's kind of the key to the whole thing.
Yeah, I mean, so I mean, the majority of the things that we set up for our clients here normally is an indemnity from a transaction. We're setting it up for them and their kids. When they fund it, and because they're a U.S. resident and they have U.S. beneficiaries under 679A4, this deemed sale on funding is postponed. And as long as it's an incomplete gift, if the grantor dies, those assets are pulled back into his estate, so they get a step up in tax basis. So then when the deemed sale occurs under 684, no taxes due because the step up has already occurred. The downside is you've exposed those assets to the estate tax, the value. So you have to balance that and think about that, because if you create one of these structures and the grantor dies during the structure, this is an issue. The other thing could be, you know, even if you have a domestic trust as well, if you get a foreign trustee, so that the trustee dies and an uncle or a sister or a friend is overseas outside the United States, you could potentially convert the domestic trust into a foreign one because the trustee is offshore, and these same rules apply. You can get a deemed sale income tax, even though the person, when they made the trust, they applied their unified credit, got it out, didn't pay any estate or gift tax, but the income tax is still there potentially.
It's very complicated, but it's a factor in which entities we choose, when we choose to fund them, and how we choose to fund them. And that deemed sale is actually an income tax. You see, we always have to distinguish in the planning
Title
between income and estate. You know, are you domestic? Are you offshore? You can even be offshore. You can be domestic for income tax and offshore resident for estate, which is a can be an advantage in planning, where we can play around with the two things.
It's a very broad topic, but we just wanted to give you a flavor for what, when you decide on an offshore, which is a great strategy and a great plan structure, but these are things you need to be thinking about and to plan for. So if you set this up, you don't have an issue later.
Yeah, and on that's a trust issue. On the LLC issue, you may have existing LLCs, they may have made the S election. You may have all kinds of tax burdens in terms of integrating those LLCs. It's a factor on the integration.
And just, and this is important because, for non-residents, both at the foreign trust level and for an individual that's offshore, there are a lot of exceptions on the income tax side for certain types of assets and things sold in the United States. The number one of which is stock, U.S. stocks. And that's a big hole in the tax code that should be utilized if you have a non-resident alien or a foreign trust. Now, that these rules apply, understand that if you have a U.S. beneficiary of a foreign trust and they distribute income to the U.S. beneficiary, they're still going to pay income tax. Just understand that. I'm not trying to say that, but there are some planning opportunities if a person's a non-resident, like alien offshore, from the perspective of if they have these assets or if they want to come in the United States, there are planning things too. But this is very broad right now. We're trying to give you an idea, but there are a lot of things here that you're able to do. But there are tax consequences to these types of structures potentially, and the compliance that you have as well by having these foreign LLC, foreign trust, the compliance and the accounts offshore, you have to comply with, and it's an expense that also needs to be thought as they move forward. And the estate's the same thing. I touched on here this deemed sale with the grantor status. This kind of gives you some bullet points of how it works, but basically, if you have a U.S. resident who creates a foreign trust and puts assets inside those trusts, unless there is a U.S. beneficiary on the funding of that trust, there's a deemed sale, regardless of the unified credit amount that is used on the actual gift. That's the main thing. I think we have some questions there.
Yeah, Tony, do we have any questions?
Yes, we have one question here. Maybe an entirely separate talk, but anything different when you talk about professional associations?
Well, professional associations, you can have either the PL, which is a professional limited liability company, or you can have the PA, which is a professional corporation. A lot of that law became a little bit ambiguous because the underlying professional ethics organizations like the CPA organizations will allow, I understand, the CPAs to form as a corp, or they can actually say LLC. Though that you just would take your LLC and then form under this professional PL, which adds a little bit of a notice to the public. It was in the 50s where they said, okay, you have to form as a PL as notice to the public, because what you do individually, you're liable for. And a huge block of our clientele are professionals, because what they do individually, like lawyers, architects, accountants, doctors, dentists, what they do, even though they're in a corporation, they don't get the inside asset protection. What they do, they are liable for individually. And in the 50s, they created this idea of putting a professional, like a PA on there, so that the public, would actually know this in a million years, but so that the public knows, okay, this is a professional organization, so the individual's individually liable. So in those situations, what we do is we create a family entity trust structure so that if they become liable, they don't give up what they have. I hope that answers it. It is a different question.
For sure.
All right, I don't have any other questions. If anyone else has a question, yes, he said yes, thank you. If anyone else has a question, now is your chance. Put it into the chat box.
And if you'd like either of my books on asset protection or the estate and gift tax and the non-citizen, just let us know. Our phone and email is up there. We're available anytime on any corporate tax or international question. We appreciate you attending.
Excellent. And that wraps it up for us today, folks. Thank you so much, Gary and Brian.